Hello friends, in this video I am going to discuss what is meaning of ubi jus ibi remedium in tort law. There are hundreds of Latin terms and maxims used in the law. Probably Latin is one of the earliest languages in which law is defined. Therefore, there are many Latin terms used in English laws to define certain rules and provisions. So, ubi jus ibi remedium is one of the Latin terms that I will discuss in this video. Let's start with the literal meaning of the term. That is, ubi jus ibi remedium. It means, where there is right, there is remedy. According to this maxim, where one's right is invaded or destroyed by someone, then the law gives a remedy to protect it or damages for its loss, whichever is applicable. Furthermore, in a case if one's right is denied or ignored or neglected, then the law instructs the remedy of an action for its enforcement. Next, that is literal explanation. Ubi means where are. Jus denotes the legal authority to do or to demand something. Ibi means there is. Remedium means the right of action, or as defined by some different source as the recovery or assertion of a right. Next, major elements of ubi jus ibi remedium. Following are the important elements of this Latin maxim. That is, this maxim is applicable only where the legal right exists. Next, a wrongful act must have been done which violated someone's legal right clearly. And the third one, that is, the Latin maxim can be applied only when the law doesn't provide either any relief or provides insufficient relief. Next, that is major limitations of ubi jus ibi remedium. Following are the major limitations of these Latin maxims. The Latin maxim is not applicable in all the cases. As for example, in a case of moral wrong, or to claim the moral right, it is not applicable. Secondly, court can't apply this Latin maxim in a case which is already recognized and a proper remedy is given. Lastly, the case in which the aggrieved party acts with utter negligence, even in such a condition, this Latin maxim cannot be applied. Case law. Ashby versus White. This case is one of the best examples of the Latin maxim, that is ubi jus ibi remedium. As in this case, the defendant, who was a returning officer, wrongfully refused to register a duly tendered vote of the plaintiff, who was a legally qualified voter, at a parliamentary election, and the candidate for whom the vote was tendered was elected, and hence no loss was suffered actually by the rejection of the vote as such. However, Justice Holt, while holding that action, said, if a man has a right, he must of necessity have a means to vindicate and maintain it, and a remedy if injured in the exercise or enjoyment of it. And indeed, it is a vain thing to imagine a right without a remedy. Want of right and want of remedy are reciprocal. Likewise, in this case, the returning officer has acted maliciously and was held liable. Watch my next videos to know more about the tort law.